Is this your first president? It's mandatory, right?
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now with plea?
Yeah.
Right there. Yeah.
What is all this?
Defamation, man. They've been gaslighting me for 5 weeks straight. I'm doing my best to get to the population going on. I'm trying to stay out of trouble. They all up on the microphone.
All right, this is, stop talking. This is clause numbers 24 DCCR 1.
Right away, you can feel the tension in this courtroom. The judge is already addressing the plea deal, and the defendant sounds like he's pushing back. That's a risky move this early. In criminal court, rejecting advice from your attorney and brushing off a plea offer can completely change how the rest of the hearing unfolds. And trust me, this situation is about to escalate quickly.
500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again. Who's in here for him?
My grandma.
All right. Ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you? Saying you're sorry doesn't matter.
And that's a huge signal right there. Judges don't normally start hearings irritated unless there's already a pattern of problems. Remember, judges review jail reports, incident logs, and previous court behavior before the hearing even begins. So if patience is already running thin, it usually means the defendant has been making life very difficult for everyone involved.
This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail. Okay.
This might seem like a small moment, but it's actually a classic courtroom control move. The judge asks the grandmother to move so the defendant can't see her. Why? Because emotional reactions or signals from family can influence how a defendant behaves in court. Judges want total focus, and when someone already has a reputation for disruptive behavior, even small distractions get eliminated immediately. That statement right there is devastating for the defense. When a judge says there are pages of reports about someone's behavior in jail, that means disciplinary incidents are piling up. Every argument with officers, rule violation, or inappropriate behavior gets documented. And if this case goes to trial, those reports can shape how a jury sees the defendant's character.
I'm going to ask you some yes or no questions. So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
She's in the jail all day long, man. When I see them women, I get burnt. I'm a little boy. I admit that.
Good, you're a lover boy.
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't.
Now watch what the judge does here. She switches to strict yes or no questions. That's a classic tactic judges use when they believe someone is rambling, dodging responsibility, or trying to control the conversation. By forcing simple answers, the judge removes the defendant's ability to explain, redirect, or shift the blame.
All of that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying?
Oh, yeah?
When you're dealing with these stressful inmates, you know what I'm saying? I love to be around my
Okay.
mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask them to go ahead and send these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. Do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think, let's go through real quick before we do this rejection. In cause number 241500, you're charged with obstruction or retaliation. Is that a third
That is a third
degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? In cause number 24 DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that? In cause number 24, DCCR 1615, you're charged with aggravated robbery, which is a first degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand? And then in 250436, you're charged with burglary of a habitation, which is a second degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand? I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison on a lesser offense of robbery. You have every right to reject that.
He was an excellent deal.
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
All these charges going to be on one trial?
They don't necessarily have to be because you've got 3 different dates.
Your Honor, the robbery and aggravated assault are in the same offense day. I'd expect to try them together.
Okay, so what can happen is you will, sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand? Okay. All right, we'll get it set for trial. Go back with the bailiff. Good luck, Mr. Burbank.
Thank you.
I don't know that I've ever been so mad at A defendant. Can't help it. Kevin Ross, Mr. Burbank.
You know we started.
Yeah. It's gonna keep on getting worse because the jury's gonna. And there's no paperwork on Mr. Ross, right?
I do have a bond.
Oh,
And this might be the most shocking moment of the entire hearing. Instead of denying the accusations or showing remorse, the defendant openly admits he's making comments to female officers because he's a lover boy. In a jail environment, that's not just inappropriate, it's a disciplinary violation. And every one of those violations chips away at how seriously the court will take anything the defendant says.